Appeals, being on the application of Kiarie and Byndloss and the Secretary of State for the Home Department.
My Lords, I've got 3 points I want to give you some reference points in relation to, and then I have 4 points that I want to briefly develop. Some reference points about us putting in evidence. In the core bundle, page 6469, it's part of SC 002, if you're working from paper. At paragraph 23, we explained what we wanted to do if we were allowed to intervene. And in part, it was to provide a practical perspective which we thought would assist the court. Paragraph 23, page 6469. We specifically referred to evidence in the letter at 6515 at the bottom, which came to you before you gave permission. And of course, we can make submissions about what happens in reality, but you would then say, well, what is that? And far better for it to be in a proper form. But the third reference point is that we cited in footnote 1 of our written case that accompanied, or was accompanied by the evidence, an authority. And it does explain why sometimes having all the authorities, even the footnoted cases, might be worthwhile, because at page 6362, volume 19, tab 220, 6362, you find Lord Steyn explaining in the House of Lords case of Sims, 6362, starting at letter D, that the House had received material which the Court of Appeal hadn't had an opportunity to consider. It arose out of an impression the Court of Appeal appeared to be under, says Lord Steyn. It's all about whether it mattered that prisoners could meet with journalists rather than correspond with them. Did that have consequences for access to justice? And then Lord Steyn describes some evidence that had been filed that the House of Lords had considered, and goes on over the next page between letters F and G to explain what he considered to be its significance in that case. So you've got the material, and we hope it will assist you, bearing in mind that you consider these cases not just, of course, for the appellants, but because there are a lot of people who will be affected by what you say.
I don't understand any objections being taken to.
No, indeed, they refer to our evidence, paragraph 138 of the Secretary of State case. Reference points, secondly, about what is in play, what's at stake in these cases. And can I take you first, please, to Lord Bingham, page 1200. It's volume 4 at tab 49. 1200. And this is the Article 8 immigration appeal case of Huang. And Lord Bingham, at paragraph 15, on page 1200, explains what happens with an Article 8 appeal in a removal case. And you'll see in the fourth line of paragraph 15, he's talking about the Appellate Immigration Authority, so the tribunal, much better placed, and then this, to investigate the facts, test the evidence, assess the sincerity of the applicant's evidence and the genuineness of his or her concerns, and evaluate the nature and strength of the family bond in the particular case. It's important that the facts are explored and summarised in the decision with care, since they will always be important and often decisive. All of that I would highlight. If you want a practical example, the reference point is page 3762, volume 11, tab 127. 3762 is the tribunal in one of these cases, deportation in country appeal, where the applicant gets to go before the tribunal. Nowadays, they often won't have legal representation. This one did. But they'll be presented even if they're detained. And Mr. Justice Blake in the tribunal explains on 3762 what then happens. The applicant is giving oral evidence at the tribunal's invitation. It's a case that had gone off the rails previously, so they're reconsidering the position.
Which paragraph are you referring?
Very top of the page, 3762, paragraph 20. He was able to satisfy us as to the current educational arrangements for the child. He produced documents for which he could not have anticipated he would be asked. Dealing with his care of the child, it supports the consistent picture that he plays a prominent role. We found his answers, 21, to be clear, detailed, and evidentially supported. Then at 22, they explain they haven't heard from the mother, but they say earlier why that is. She's disengaged. She won't talk to him. And at the end of 22, they reached a view different from the one that had previously been reached as to his credibility on the account for the care arrangements. At the bottom of the page, 25-26, they reached their conclusions. That's what this is about, in real, practical, and human terms. So, taking the position of my charity, that's the position for the 19 clients that Mr. McLuth describes at paragraph 37, page 6831. The first 19 that they've helped with, they started helping in this field in concern with bail and detention for a very long time. But here, with legal aid gone, they're trying to help those that they can in deportation cases. The first 19 in-country appeals, 11 succeeded. Paragraph 37. And they've had a first 9 Section 94B certification cases. Here's paragraph 39 at page 6832, and I'll come back to those if I get time. We are a charity then helping, after the withdrawal of legal aid, paragraph 34 of his witness statement. These are, in the charity's experience, typically vulnerable individuals who struggle. They face very real obstacles. Paragraph 7 on 6823 and 23 to 33 on 6828. And he emphasises twice, at paragraphs 36 and 53, 6831, 6836, 36 and 53. BID can only help a very limited number of cases, and they are very concerned about everybody. Reference points, thirdly, about resources. And we make the point, you may have seen it in our written case at paragraph 10 on page 6812. We didn't say British High Commission, we did say embassies. At 6812, in the core volume, paragraph 10, we say this: what should be recognised, fourth line of paragraph 10, is that no change has been made to make the out-of-country appeal a properly resourced alternative. It is not as if the government decided to fund the provision for the tribunal and at UK embassies in countries of return of readily accessible video link or Skype rooms for out-of-country appeals. There's no change in relation to resources, even now, even after this case has come all the way up for this court to consider the position. And the evidence that we put in, it includes some correspondence, because we've done one out-of-country appeal where we as the charity were able to assist the individual who had been removed. And we write a letter at page 6842 in the core bundle. This is June of last year, and we thought it right for you to see this material. We had sought the opportunity of evidence from overseas, and there were some Skype directions. They're set out at page 6835, and they're very onerous. And you've seen NERE and I think the practice note that relates to it. So we write to the President at 6841 when we explain the sort of costs we're talking about simply for the UK end. This is Taylor House in London, paragraph 2 on 6842. and we make a request in the middle of that page, 6842, given the tribunal's interest, and bearing in mind everything that you've read and seen about tribunal's got a duty, we'll have to make it happen if it's needed, and so on and so forth. The tribunal buys, installs and maintains its own equipment at hearing centres. And the answer we get back at 6844 in the middle of the page, 6844, tribunal, it says, will always ensure that no one is disadvantaged in terms of the outcome of appeal because of lack of resources. But then this, unfortunately, the tribunal has no funds to provide equipment or technical ability, hence the onus in that regard we have to place upon appellants and their representatives. And Mr. McClure explains, our charity has to buy a projector and a laptop and an internet subscription for the tribunal in London before they can be Skype. And they make the point that their clients wouldn't be able to afford that if fending for themselves. And that individual only gets to be able to participate because he has a lawyer he knows in the country of origin and is therefore able to go and use Skype from that end. And that's all set out in the witness statement. And yet here we are, the Secretary of State continues merrily to rely on video link. And the Court of Appeal accepts it. And witness summons, which appears to have disappeared now. Can't find that in the printed case, but it's certainly in the Court of Appeal's judgment. 4 points, then, that I wish just to develop, please. Firstly, the generalisation that the Court of Appeal made at paragraph 71 ought not to be endorsed by this court. And the generalisation that the Court of Appeal makes at paragraph 71 is that the Secretary of State is entitled to proceed on the basis that an out-of-country appeal will meet the procedural requirements of Article 8 in the generality of criminal deportation cases. We say with respect, that's not a generalisation that is sustainable, but it's very damaging because thereby lies the path to routine certification.
Was there any evidence to support that, you would say? And we have your evidence now, which they didn't have.
I say it's not supported. It's not supported by the reasons either. I mean, the high watermark of it is it's not inherently...
I can read the reasons. It's just really a question of whether they had any equivalent evidence to what we now have.
Welsh was the only evidence there.
Yes, they had that. They've had what you've been shown.
Yes.
Yes.
But I mean, I did suggest yesterday that this might be something where one really needs the upper tribunal to hold a sort of hearing, really to consider what the practicalities are. If the onus is being put on them by the Secretary of State to ensure that things are fair, well, they obviously need to be properly resourced to do that, one might think. But I don't know what the attitude of the tribunal service would be, or indeed the Secretary of State. But
well,
we have no evidence about
and
that.
the Secretary of State is here being encouraged to certify by a Court of Appeal that says you can proceed on the basis, then generally this is fine. On what basis? We respectfully say. And bearing in mind, the Secretary of State is looking at a question prospectively and has to satisfy herself of a negative, would not breach. We say it is necessarily going to be a very fact-specific question as to whether it can be right and justified to remove first and ask questions later through the medium of what is supposed to be an effective appeal. And so quite helpful, we would submit, are the sorts of factors that you saw in the legal aid case. Goudan, I'll call it, at volume 10, tab 111, it's electronic page 3412. 3412 in volume 10. At tab 111, and they're dealing with Article 8 procedural from the perspective of whether the deportee having a fair hearing needs legal aid. You could have that. You could have a question of interpreters. You could have a question of oral evidence. If they said no more detainees being brought to Taylor House, we're going to save money on vans. Then you'd have a question about video link. But the sorts of factors you'd need to look at, page 3412, would surely be paragraph 72. The particular facts and circumstances of each case, including the importance of the issues at stake, the complexity of the procedural, legal and evidential issues, that's to say in the individual case, the ability of the individual to represent himself, here it's without legal assistance, but whatever the obstacle is, insert, having regard to his age and mental capacity, and then features such as restrictions on advice and assistance, language difficulties, complexity of the law, and its rapidly evolving nature. Those are the sorts of factors, and you've got to grapple with them. If the legal aid agency had a statutory duty to certify a negative, this case will involve no breach of Article 8 if this individual has no legal aid. It would have to grapple with all of these factors. You can't say generally that live evidence is unnecessary. You can't say generally that the claimant's evidence is unnecessary, nor that Skype or video link is satisfactory, still less that Skype or video link is available. And this is all supposed to be practical and effective. And you certainly can't say, oh, well, the tribunal can direct it, as if it was a detainee and you're directing them to be presented, as a Crown Court would or as the tribunal could. There's no power to do that. The witness summons solution is no solution at all. And you can't generalise either about the other limb, the substantive limb of Article 8. Is it proportionate to send away on the basis of appealing abroad and come back if you win? So if you take the 4 points that Lord Justice Richard summarises from the Secretary of State's submissions, it's at paragraph 60 in the Court of Appeal. It's quite a helpful port of call. Paragraph 60 in the Court of Appeal's judgment. You've got, maybe able to determine without oral evidence, consider the written evidence he submits, and then you get 4 things. He can, if he wishes, instruct a lawyer. Then you get the determination is more likely to turn on the evidence of family and friends than on complex legal arguments. Then you get the tribunal can secure Skype, and then you get the tribunal can require attendance. Wrong times 4. And no support for any generalisation. I'm not going to ask you to generalise the other way. I'm just going to ask you to accept that it is going to depend, and it is dangerous to be giving signals to the Secretary of State, oh, this is usually fine. Next point, second point to develop, the duty of inquiry. Mr. Gill is right. The Secretary of State must have an important duty of proactive inquiry in these cases. Why is that? Well, firstly, the statute frames the precondition as a question for her. Rather interesting, because it's a question of law. Would there be a breach? But here, she is given the discipline that she answers it first. I'll come on to who answers it second. She has to ask herself the question, and she has to satisfy herself of the negative. No, it will not breach. And it is entirely conventional. It's paragraph 23 of our written case, page 6817, and obvious that a decision maker must take all reasonable steps to acquaint herself with relevant information to answer the question. And if that means getting views of an outside agency, well, then that's the duty, and there's authority for that, and we've cited it at 6817 in our written case. But then, of course, there's section 55 and the best interests of children. And as Mr. McCloof explains at paragraphs 9 and 17 of his witness statement, 6824, 6826, 6824, 6826, paragraphs 9 and 17, they routinely don't. And it's their case, they don't have to. The onus, they say, is on the individual deportee. Now, I do just want, I said I would if I'd got time, I think I dare do this, to take you to the schedule at page 6846. We've had 9 of these, section 94B certification cases. And Mr. McCloof explains the sorts of characteristics, it's at 6832 that you find, and he says that in his view that they're not atypical. And he then gives some details at 6846. And it's quite interesting just to see these examples. OD, 12 years in the United Kingdom, 3 British children, 2 autistic. HI, 31 years in the United Kingdom with mental health difficulties, vulnerable, and 4 British children. GL, 14 years in the United Kingdom with 7 British children, and then skipping one because he claimed asylum. Number 5, KB, 11 years in the UK with a mental health condition. All of those were certified by the Secretary of State under Section 94B, as were the others in the schedule. Interestingly, BID were able to persuade the Secretary of State to withdraw those certificates. She didn't take the position she's taken in this case. I might look at that later, or I will look at that later, but not now. And in all the examples I've just given you, by pointing things out, the certificate is withdrawn. Sometimes it's maintained and then there's a threat of judicial review, but they are all withdrawn. And the point Mr. McCloof powerfully makes is that's because we were there to help, and it demonstrates there isn't an inquiry. Because these are points that the Secretary of State should have found out. So an inquiry, what is the capacity of the individual? What are his or her resources? What's the health position? What's the mental health position? Will this person have a lawyer? What's the language position? What's the environment in the country of return? Is video link a realistic prospect? Will there be Skype? And then what about this? What about inquiring into the alternatives? If this is someone who's said to be a serious risk, well, they can be detained under Hardy Singh if they're an abscond risk. Get on with the appeal. Or what about let him stay while he files the appeal and gathers the material in support of it? Or what about let him return for the appeal hearing? Mr. Gill is also right that SS Nigeria goes nowhere near supporting the idea that the Secretary of State can sit back and the onus is on the claimants. SS Nigeria, I haven't got time, but it's 3322. Volume 10, paragraph 107. And the Court of Appeal at paragraph 57 emphasises that that was a case where the Secretary of State had made inquiries. Lord Justice Law says at paragraph 58, the issue, impact on the children, must be properly gone into. And in the concurring judgment at paragraph 62, the point is made that it's for the Secretary of State who would take such appropriate inquiries as are necessary. But you've got it in all the children cases. ZH Tanzania, it's paragraph 36. My Lady Hell, page 1737. And the extradition case of H, it's paragraph 86 at page 2117. So that's 1737, paragraph 36. 2117, paragraph 86, and the bundle references are volume 5, tab 61, and volume 6, tab 70. I'm racing, but I have to because I've got 2 other points. This is an area that plainly needs an impact assessment. Impact assessments are always proactive, they are always prospective, and they have to get to the bottom of what the impacts are. Third of my 4 points, the nature of judicial review. I said the question is first for the Secretary of State under the statute. Would this breach? The question is secondly for the court on judicial review. And I just want to explain that because the Court of Appeal, we would say with respect, are completely wrong to speak of Wednesbury at paragraph 33 and perversity at paragraph 93, and whether a view could reasonably be taken at paragraph 100. That would have no place in a human rights context anyway, perversity and Wednesbury. But there's a particular additional reason we submit in the present context. Go back to section 94B, and there are two things. There's the statutory precondition of 94B2. It's at page 258 in volume 1, tab 12. And then there's the discretion, may. And the discretion is reviewable. That will be conventional but anxious scrutiny because we're talking about a fundamental rights context. But the statutory precondition is an objective question of law, and it relates to executive action. The executive action is removal pending the appeal. That action is action to which Section 6 of the Human Rights Act applies. Removal for the appeal is unlawful if it's incompatible with Section 6. So when the Secretary of State is considering the question would not be unlawful under Section 6, that's the question a court would have and would always have. Objective question, question of law. And moreover, the deportee has the statutory entitlement to have that question decided by a court. You cannot remove me where the removal might breach Section 6 without me being able to get to a judge who decides whether it would breach Section 6. And there's nothing in the terms or design of the statute, there's no usurpation of the Secretary of State's role when the court recognises what I've just said. This is Section 6, and this is the Section 6 function. It hasn't disappeared because the Secretary of State does it first. And any court deciding that question, would removal breach, has to make relevant findings relevant to that question. And if it's removal pending appeal, it's questions of fact relevant to removal pending appeal. There may not be many questions of fact relevant to that. But if there are, they have to be determined so that that question is answered, and it must be answered on the material available to the court. Secretary of State says, I don't accept that your child's been taken into hospital diagnosed with leukemia. All right. Judicial review. Here's the material. Yes, she has been. Removal would breach Article 8. Yes or no? Or I don't accept that you've shown that you're the father or that you have an active role. And if the Secretary of State chooses to make those sorts of questions material to certification, material to where the appeal should be from, it's no answer at all to say, well, that'll all come out in the wash. You can decide those questions on the appeal. This is a question about where the appeal should be from, and it's a human rights question about where the appeal should be from. Now, everything I've just said is supported by all the authorities. The extradition case of H, paragraphs 151 to 152, bundle 6, tab 70, explains that where the court has the role of deciding the would breach question, it looks at the evidence and decides the questions for itself. Electronic 2805 and 2807. Hesham Ali, volume 8, tab 84, it's paragraph 7 to 8 of Lord, 7 to 8 and paragraph 13 at 2134 and 2135. Same thing there, the statute says, would the removal breach? And once you're into that question, then you've got to decide, you decided objectively, and you roll up your sleeves. Secretary of State's position is very odd, and so the Court of Appeal. They accept that the proportionality question is for the court to decide. That proves that this is not about, could the Secretary of State rationally conclude that this would not breach? It's not that. And that's common ground. Secretary of State accepts it. But once it's right that it's not that, the question for the court is, would it breach? Then with respect, it's completely wrong for the Court of Appeal to say at paragraph 93, don't trespass on the appeal that's coming, or don't usurp the role of the Secretary of State. in deciding this question, paragraph 99, in the Court of Appeal. And if all of this were wrong, the only thing that would happen is that the judicial review would be recast. You wouldn't judicially review the certificate anymore. You would judicially review the removal to appeal from abroad. You'd say, that's action of the executive. I have a right under Section 8 of the Human Rights Act. It's no good for me to JR the certificate because that's an irrationality test in relation to the Secretary of State's view, so I have to JR the action. And the court would then have to deal with all the issues itself. This is supposed to speed up the efficiency of deportation. We say all of these points, duty of inquiry, court looking at the issues on the evidence, have those proper protective advantages. And finally, I see the time, so I'm already in extra time, and I do
Well, we were
apologise.
a minute or two late coming into court, so that's why I haven't
Lord
stopped
Keane
you
has been
yet.
very kind to tell me that he's relaxed. So I'm not, but I'll. All right. He's not going to glare. Final point. I just want to make a couple of points on the authorities on Article 8, particularly given that what the Secretary of State is now saying is a departure from what the Court of Appeal accepted at paragraph 49, which was the Goudan legal aid approach. And the points I want to make are these. First of all, IR in the UK is helpful. That was the SIAC case. Volume 16, tab 178, and particularly helpful, paragraphs 63 to 64, that's where they're analysing, Strasbourg is analysing the SIAC process and the participation that you can have and the protections that you have, the legal representation and the special advocate and the maximum disclosure and so on and so forth. It's electronic 5224, but all of that chimes with the standard of fairness and the sliding scale and everything that has been acknowledged and Mr. Drabble addressed you on. Chilich is also helpful. That is volume 13, tab 153, and particularly paragraph 66, where the standards, familiar standards are articulated. It's electronic 4455. 4455. And it's helpful not just because the Court of Appeal cited it in Goudan. It's illuminating. It's an immigration case. It's an Article 8 family life case. And it's the context where the obstacles relate to the parents' opportunities to participate in a procedure which will decide whether he will gain access to a child. And in that case, if you remove them and there are obstacles and there can't be practical participation, those are the standards that apply under Article 8 procedural protection. How can it possibly be a lesser standard when you're removed and the obstacles relate to participating in a process which isn't about whether you will gain access to a child, it's about whether you will lose it for 10 years or possibly more, because you'll be deported and excluded. There is no logical reason why that could possibly be so, and no basis on the authorities, we respectfully submit, for reaching that departure conclusion. On D'Souza and Khalifa, I simply wanted to emphasise that in neither of those cases did the Strasbourg court need to get into the particular facts and circumstances of the out-of-country option. And I do just want to explain that, and then I promise I'll sit down. D'Souza was the removal case where the Judicial Review Court then decided that removal was unlawful. And Strasbourg explained that the issue, I'll call it the out-of-country issue, had been properly decided by an appropriate body. That's the conclusion that Strasbourg reaches in D'Souza at paragraph 92 on page 5249 in volume 16, tab 179. But they don't need to analyse it in any detail or in any depth, because what it came to was this. That court could and did properly and effectively decide the issue that arose in that case. And what was the issue that arose in that case? Top of 5233, the French code said you can't remove someone if they've been habitually resident since the age of at least 13. Top of page 5233. And that issue had been ventilated by the claimant, and he won. And he wins at paragraph 23, at the bottom of 5231. They make findings, they refer to the evidence that he had provided, and they conclude, very bottom of the page, that because he met that habitual residence condition, it was an unlawful removal order. And that was the end of it for that aspect of de Sousa Ribeiro. They didn't need to get into questions of what if there are obstacles, what if you can't effectively participate. It just wasn't an issue. What was an issue was, what should have happened before I left? Is there an automatic right to a suspensive remedy? No. Was there a sufficient prior examination of the issues? No. And that's all the analysis that you've seen and that follows. In fact, he had returned paragraph 22 on 5231 by the time of the judicial review, but one doesn't know. Anyway, Khalifa is very similar. Khalifa is actually an issue of collective expulsion, where the only issue then that arises under the relevant convention protection is, were the individual facts considered before these people were all shipped back to, I think, Tunisia from Italy? Nothing to do with Article 8. They hadn't even landed. They hadn't got families or roots or anything. They were just put on a boat. So the issue is, were the individual circumstances considered? No, they weren't. And the two people who sought the out-of-country remedy won. And that's paragraph 31 on page 5354, volume 16, tab 182. Two people who asked the question win their cases. And that is why Strasbourg says at paragraph 272 of Khalifa on page 5434, there is no evidence to doubt that that was effective, that right was effective. But these cases aren't saying anything about a case such as ours, where the whole issue is as to whether the sorts of practical and real obstacles that will arise will infringe the principles that are applicable in both the cases. They were satisfied for good reason, that the issues that arose had been effectively determined. Thank you for having us. Thank you in particular for letting us make oral submissions. We're very grateful to the court.
Thank you very much, Mr. Fordham. Thank you.
Lady, my lords, I'm obliged. Could I just begin by touching very briefly upon part of the history of these cases, because it touches upon a point raised by my Lord Carmarth, both today and yesterday. A judicial review was brought by the appellants. That was brought before the upper tribunal, a tribunal versed in dealing with this type of deportation case, and they were refused leave. An application was made and granted for an oral hearing on leave before the Court of Appeal. And that application for an oral hearing, having been granted, the matter proceeded to the Court of Appeal, who, as your lordships will be aware, granted leave but refused the applications for review. Of course, the Court of Appeal might have granted leave and remitted the matter back to the upper tribunal, but chose not to do so, as it clearly felt confident of being able to determine the matter on the basis of the material that had been placed before it.
Was it asked to do so by anybody? Was it asked to remit the case to the upper tribunal?
I don't
by anybody?
believe any request was made by any party for it to be remitted back, milady. I'll be corrected if I'm wrong, but I don't recall. My learned friend, Mr. Rowell, points out that no such application was made by any party, and the Court of Appeal made clear at the permission stage of the hearing, that's a conjoined hearing, that it would deal with the matter on the merits.
It has in recent years become pretty standard practice if the Court of Appeal decides it's going to grant leave for it to hold the matter to itself. And this just followed the ordinary routine.
It did.
The question which has been running through the minds of some of us during this case is whether that was a wise decision or not. It might have been a more appropriate one to send back to the tribunal, given the tribunal's experience in relation to these various matters.
It is that last point that, of course, I believe may have prompted my Lord Carmarth to raise this yesterday, that the tribunal itself has immediate experience of how to deal with this sort of application.
It was more than that. I mean, I'm recalling a case where we had a problem about how to deal with appellants from mental health hospitals and video links. And so we set up a special hearing, which I presided over, and we had someone from the Mental Health Tribunal. And one of the great advantages of the tribunal model is that you could, for example, get in the president of the first-tier chamber who's entitled to sit in the upper tribunal. So you could actually have a special panel which would have, in a sense, a test case on this sort of issue. But I don't think anyone suggested that, but it may be something which we should be considering. I don't know.
I raise this point because I want to draw attention to something that I will come on to deal with in a little more detail in a moment, and which hasn't been mentioned so far. The parties to this process were asked to complete, and did complete, a joint note for the benefit of the court, setting out the procedural issues that the upper tribunal would deal with, or the tribunal would deal with, in a case of this kind when having to address an out-of-country appeal. And I'll come on to look at the detail of that joint note in due course. In addition, there was, of course, some evidence submitted to the court about such procedures, in particular from one of the appellant's solicitors, Mr. Sharma. And over and above that, as the learned friend Mr. Fordham has just alluded to, we also have details of notes prepared by the tribunal for the taking of out-of-country appeal evidence where required by Skype. And I'll come back to the letter that my learned friend briefly referred to in order to look at the totality of what the tribunal were saying with regard to these matters. But I accept that there are circumstances in where it might be thought appropriate to refer the matter back to the relevant tribunal. I would observe here that no one made such a request of the Court of Appeal, and that in the event, the parties did submit to the Court of Appeal a joint note on procedural issues which would arise at the tribunal in the context of an out-of-country appeal. So it was against that background that the Court of Appeal was then proceeding. The second point I would mention very briefly indeed is just the provisions of section 94B. I'm not going to go to, your lordships are familiar with the provision by now, and the distinction between subsection 2, which requires that there should be no breach of human rights pursuant to section 6 of the Act, and then subsection 3, which deals with a distinct issue, largely reflecting the position that there would be no certification in a case that engaged Articles 2 or Articles 3 of the Convention. And I acknowledge that at the outset of the implementation of Section 94B, the guidance which had been issued was erroneous insofar as it relied upon the provisions of subsection 3 and not expressly upon the provisions of subsection 2. That, as your lordships may have noted from the submissions of my learned friend, Mr. Gill, has been rectified. But I acknowledge that...
When was that put right, we were told?
It was put right before this matter was heard, I believe, by the Court of Appeal.
But at the time the decisions were made, the guidance was defective.
I'll check the precise date when the guidance was amended, my lord, but I have to acknowledge that there was an error in the guidance at an early stage. I'll check the date when it was...
But it's quite important to know what was the position when these decisions were made, rather than when the Court
Indeed,
appealed.
and I will confirm that, my lords. On behalf of the appellant Kiarie, my learned friend Mr. Drabble opened and indeed made an extensive submission on the matter of procedural fairness. And he did so under reference not only to his case, but to the supplementary case that had been lodged on behalf of that appellant. And the summation of that appeared to be that one should treat the test arising under Article 6 of the Convention as being the same as the test arising under Article 8. And that led on to a proposition reflected at paragraph 158 of the appellant's case, that the Court of Appeal should have embarked on a fact-finding mission. And indeed, in the supplementary case that was lodged, the appellant sought to base his argument on what was termed in his case a separate strand of authority which concerned the application of Article 6 to quasi-criminal and disciplinary proceedings, and led on to a submission based on cases concerning possession proceedings in order to arrive at the proposition that the court must embark on a fact-finding exercise. The cases in question were Connors and Pinnock, and your lordships may recollect that as my learned friend Mr. Drabble came to the close of his submissions, he said he was going to address those two cases, but it did not make any substantive reference to them at all. But the line of argument is reflected in the supplementary case lodged on their behalf. Now, my lords, let me say for the avoidance of doubt that the Secretary of State accepts that there may be a considerable degree of overlap between Article 6 and the procedural aspects of Article 8, and that the underlying principles of fairness and effectiveness will in both cases vary in their application depending on context. But that is not to say that they are the same. And it does not bear out the proposition that the court must embark on a fact-finding exercise of its own in these circumstances. We have rehearsed the Strasbourg line of authority in our own case from paragraph 62 through to paragraph 83, that's at MS 4431. And I don't intend to take your lordships through that in any detail, but I would just note, by reference to the case of Moa, that Strasbourg has expressly held that Article 6 does not apply in the present context.
I wonder if one can short-circuit this perhaps rather arcane discussion by going back to what the Secretary of State does have to satisfy herself about. It's, I think, accepted on your side that she does have to positively consider whether exercising the power to certify under that section would risk violating the person's human rights. And to that extent, she's got to examine the facts and circumstances and take a view on them.
Indeed.
Now, if that's accepted on the statute, then I just wonder whether debate about the similarities and dissimilarities between Article 6 and Article 8 takes matters any further.
In my respectful submission, it may not take one any further. I'm slightly concerned at the way in which the appellant Kiarie has sought to develop this line of argument to the conclusion that somehow the provisions of Article 6 and the procedural requirements of Article 8 are the same. They certainly are not. And that way lies confusion in my respectful submission. But if I may take up my Lord Toulson's point and say that the matter, in a sense, can be short-circuited, in my respectful submission, he's quite right about that, because even if one is to approach this under Article 6 as being relevant, the Strasbourg Court has recognised that where administrative decisions are concerned, judicial review can satisfy the requirements even of Article 6. And could I just mention in that context, because it contains a review of the relevant authorities, the case of XH and AI, which was handed up this morning and made available to my learned friends yesterday. It's a decision of the Court of Appeal dated 2nd February of this year, if your lordships have it. And the court comprised the Master of the Rolls, Lord Justice Lloyd Jones and Lord Justice Sales. I don't think it's necessary to go into the detail of the case, but if I can take you to the judgment of the Master of the Rolls, which was the judgment of the court. First of all, at paragraph 137. And this was being addressed in the context of Article 47 of the Charter and Article 6. And in the last sentence at paragraph 137, his lordship observed, it is possible to examine the facts on which a measure is based without undertaking a primary fact-finding exercise. And the relevant authorities are then considered. And at 143, there's reference to the case of Runa Begum, which concerned a determination by a local authority officer following an internal review that an offer of accommodation to the homeless applicant was suitable and her refusal had been unreasonable. And on appeal to the county court, the judge held that the authority's failure to direct a review by an independent body rather than conducting a final review by its own officer contravened the claimant's rights to fair determination of a civil right under Article 6. The judge's order was reversed by the Court of Appeal, which was upheld by the House of Lords. Notwithstanding the fact that the decision had not been taken by a body clothed with the independence and impartiality required by a judicial tribunal, Lord Bingham found compelling support in the Strasbourg jurisprudence for the conclusion that in such a context, the absence of a full fact-finding jurisdiction in the tribunal to which appeal lies does not disqualify that tribunal for the purposes of Article 6. One of the matters which Lord Bingham considered particularly pertinent in this regard was that although the authority may have to resolve disputed factual issues, its factual findings would only be staging posts on the way to the much broader judgments which the authority had to make. And then there's reference to the case of Ali and Birmingham City Council and to Lord Hope's observations. And in particular, over the page, the last part of that quotation, in these circumstances, I would hold that the ratio of the decision in Runa Begum's case should be applied, and that the absence of a full fact-finding jurisdiction in the court to which an appeal lies under Section 204 does not deprive it of what it needs to satisfy the requirements of Article 6. There's then a reference to Ali being upheld in the Strasbourg court. And at paragraph 147, it's observed about halfway down, in making her decision, the Secretary of State is obliged under domestic public law to act fairly, and the court and judicial review can quash a decision if she does not. Of course, what fairness requires in relation to disclosure may be affected by the national security context, such as it is under EU law. Conventional judicial review is a flexible remedy which can extend to investigation of the factual basis of a decision where appropriate, without assuming an independent fact-finding role. And we would accept that, my lords, in the context of Article 8 and the issue of procedural fairness. Judicial review is a flexible remedy which can extend to an investigation of the factual basis of a decision. But that is not the same as asserting that the court proceeding with such a review should itself and of its own volition be obliged to proceed upon its own fact-finding mission.
So are you supporting the Court of Appeal's position that at the fact-finding it's purely Wednesbury test?
Essentially, the fact-finding is the exercise carried out by the decision-maker, which is then the subject of anxious scrutiny by the court.
So it's not Wednesbury in the traditional, very narrow sense, it's a more flexible.
Indeed, sir.
No, because if the Secretary of State, came to a view which the court disagreed with, and the court formed the view that on those facts there would be a breach of Section 6, the court would have to act.
Absolutely. And it touches also on why we wholly accept that it's for the court to come to its own view on proportionality. There's nothing obscure or exceptional about that, as Malone and Mr. Fordham.
But it goes, Mr. Fordham goes beyond that. He says, well, actually, it's not simply a question of reviewing the Secretary of State's decision. It's actually the court deciding for itself whether this action is contrary to Section 6.
Well, indeed. And there, I say, he goes too far.
There are levels of fact. If you bore down to the, if you like, the bottom level, you've got questions of fact as to how often this defendant this appellant has seen a particular child. That leads up to another tier of fact, which is whether there is a real relationship between them, which may lead up to another question, which is whether this would be harmed by separation, leads to a question whether it's proportionality. Now, they're all, in one sense, questions of fact, but a rather different kind. You say when you go down to the question whether there is a meaningful relationship between a person and a child, that's a question of fact for the Secretary, subject to review, but not by decision of the court. But you accept, I think, that the review involves strict scrutiny. And therefore, if the court finds itself saying, well, I really don't think that can be the right conclusion on the evidence before the Secretary of State, then the court doesn't have to go as far as saying, well, it's Wednesbury irrational. They can simply say it doesn't withstand strict scrutiny, can't it?
Absolutely.
Yeah.
And to take a simple example, if the Secretary of State had determined that there was, for example, in a hypothetical case, no parental relationship between one individual and a child, and it was quite clear to the court on an examination of the material that was before the Secretary of State that such a parental relationship clearly did exist, then the court could proceed on that basis.
Yeah. What about the issue whether Mr. Drabble's client has ties in Kenya? Is that something for you or for the court or for whom?
Well, again, the court would look at the material that was before the Secretary of State, the primary material, and see whether it justified a conclusion that such a link could or did exist. In the case of Mr. Kiarie, there was primary evidence on that about the fact that there was a grandparent in Kenya, that regular sums of money were sent out to the grandparent, that Mr. Kiarie had visited Kenya on a number of occasions, albeit he expressed those visits as being holidays. So that there were primary findings of fact upon which a decision could be made on that issue. But what I submit is this: it is too bold to say that the test under Article 6, as it's been developed, taking into account such cases as Pinnock, is the same as the test to be applied to the procedural fairness requirements of Article 8. Of course they overlap. But that's as far as it goes. And it doesn't take one to the conclusion that the court should be the primary decision maker on the facts, or should be making the primary findings of fact. Reference has been made repeatedly to the case of Goodovician, and I don't propose to take your lordships back to it. It's at MS 3412. But clearly, the court was expressing a view in that particular context. And they say that repeatedly. So again, that, in my respectful submission, does not advance matters at all. But having developed this line, the appellants then seek to assert, and indeed, certainly my learned friend Mr. Drabble sought to assert, that an out-of-country appeal cannot be an effective remedy for the procedural requirements of Article 8.
Don't think he went so far as to actually say can never be.
He then qualified it, my lord, as did my learned friend Mr. Gill, by saying that there could conceivably be exceptional circumstances. I think my learned friend Mr. Gill alluded to what amounted to a clear and present danger from an individual that might justify such a step, although my learned friend Mr. Fordham indicated that there wouldn't even be a requirement in those circumstances. In making this submission, a great deal of emphasis was placed by the appellants on the necessary requirement for an appellant to give oral evidence. The learned friend Mr. Drabble referred to it as a critical issue, and in particular the appellant's evidence about his propensity to reoffend being a critical issue. He went on to refer to the central issue as being whether or not the appellant was rehabilitated. And reference was made to the case of Georgiou, which is simply not in point. The case of Georgiou, it's at MS 3913, concerned an EEA. It's at tab 137, my lord, electronically at MS 3913. And if my lord allows me, I'll just check the...
Volume 11.
It's volume 11, my lord, I'm using. The issue in that case was whether or not Mr. Georgiou presented a present threat. because that was the test as applied to an EEA national. Point was brought out at paragraphs 21 and 22. Now, the issue here is not whether or
But
not...
he's there distinguishing this case, isn't he?
Exactly so. The issue in this case is not whether or not the appellants present a present threat. The issue is really quite distinct. Parliament has expressed the view that it is in the public interest that foreign national offenders or criminals should be removed from the country, and that such a removal should be possible even where and pending an appeal against such an order, with the result that an out-of-country appeal will have to be pursued. And that arises as a matter of public interest whether or not the individual presents a present threat. It has, amongst other things, a deterrent effect upon foreign nationals who might otherwise believe that it would be appropriate to indulge in the supply of Class A drugs. They will know that Parliament has determined that in the event of them being arrested and convicted for such offences, they will be removed from this country as soon as is practicable, having regard to any rights that they enjoy under the Convention. Now, as well as referring to the case of Georgiou, my learned friends also refer to the observations of Mr. Justice McCloskey in the case of Murbullah, which is at tab 139. That's in volume 12, my lords, MS 3970. And they do this to illustrate the unsatisfactory nature, or what they allege to be the unsatisfactory nature, of an out-of-country appeal. And of course, your lordships were taken back to observations of the late Lord Fraser in a case in 1984, and to various references since. And it was brought more up to date by referring to the case of Murbullah, and in particular to observations of Mr. Justice McCloskey at paragraphs 89 and 90. That's at MS 4003. It's a passage that begins with the heading, "A footnote." And I would just observe that what was said there began in these terms: "We would observe that the forum of an in-country statutory appeal would be clearly superior to the hybrid model adopted in these proceedings for the full exploration and consideration of all the evidence, and in particular, the finding of whether the applicant engaged in deception as alleged. This signs in our conclusion concerning conspicuous substantive unfairness. The suitability of an out-of-country appeal in this sphere of litigation, and indeed in others, has not yet, to our knowledge, been fully tested at either tier, and thus remains a moot question. In this context, we draw attention to what this tribunal said in SM and Cadia." But it was the particular issue that engaged the tribunal in that case, one of deception, one where you would potentially want to examine, by way of oral examination and cross-examination, the relevant appellant. And his lordship went on to observe that the question of whether mechanisms of this kind are satisfactory, and in particular the legal question of whether they provide an appellant with a fair hearing, will depend upon the particular context and circumstances of the individual case. And let me be clear, we do not suggest that there are no cases in which an out-of-country appeal would be unsuitable. But the appellants essentially go to the other extreme, and with some minor qualifications, suggest that they can never be suitable as a means of disposing with procedural fairness under Article 8 of an appeal of this kind. And the essential effect of the appellant's analysis is that the Secretary of State should not be permitted to use the certification bar in Section 94B in cases involving foreign criminals, and that's clearly contrary to the intention of Parliament. Parliament conferred these powers with the intention that they should be used. And yet the logic of the submission made by the appellants is that you can never have a fair hearing for the purposes of Article 8 if you have an out-of-country appeal against a deportation order.
Well, it might be a little bit more subtle than that, mightn't it? It might be you can't, as things stand at present, under the arrangements that there currently are, have a fair and effective procedure from out of country. And if the Secretary of State, or indeed either of the relevant Secretaries of State, because it seems to me that the Secretary of State Justice has got a potential role in this, get together and make the arrangements, pay for the proper video linking and so on, enable the tribunal to operate in that way, well, then it might be all right. But as things stand at present, it isn't.
I take the lady's point. But just to conclude on this earlier issue as presented by the appellants, the conclusion of the Court of Appeal under reference to the issue of procedural fairness for the purposes of Article 8 was that certification would not breach the procedural requirements of Article 8 in the generality of cases. Now, that conclusion has been criticised by my learned friend Mr. Fordham, but that conclusion in my submission was correct and is not affected by the point that the Lady Hale has just raised, to which I'm going to come back in just a moment. Of course, it's not impossible to conceive of a case in which the appellant's presence would be required. But what the appellants attempt to do in this case is essentially characterize this as a binary issue. Deportation appeals in the absence of the appellant are either fair or unfair. It's not a binary issue. They insist...
You've accurately summarised what the Court of Appeal said about the process being fair on the evidence before it in the generality of cases. Now, a person who's liable to deportation because of criminal conviction has, in many people's views, rightly, a very considerable burden to show that his or her removal would be in breach of his human rights, is he not? In many such cases, the person will be asserting a level of family involvement which the Secretary of State will not have accepted. Would you accept that as a commonplace?
I wouldn't accept it as a commonplace, my lord, and I'll come on to explain why in a moment, because in fact the Secretary of State does make very detailed inquiries about that very issue before proceeding to certification under Section 94B. We haven't looked at it yet, but there is the matter of the questionnaire that is submitted to a party before any decision-making process.
But those who've read refusal letters many times may be familiar with perhaps a general tendency not to accept that there is as strong a link with children, with other members of the family, as the applicant is contending for. You say that would be an erroneous impression.
I would submit that it would be an erroneous impression. As I say, when we come to look at the questionnaires, and I'm going to look at it in a moment, we'll see the detail of the inquiry that is made in that context. But can I take a step back? Because the primary submission made on behalf of these appellants, as I understand it, about the issue of an out-of-country appeal not meeting the procedural requirements of fairness under Article 8, turned repeatedly upon whether or not he would be able to give evidence about his propensity not to reoffend, it's referred to as a central issue, or the fact that he's sorry as to what he's done and will not do it again. And the point I seek to make is that these are not central issues in the context of this sort of hearing at all. How often would you anticipate that before a tribunal, an appellant would turn up and say, I fully intend to continue supplying Class A drugs? It doesn't happen. There will be expressions of remorse, perhaps. But again, it's not an issue of present threat. There are certain primary facts that will be available to any tribunal, whether or not the appellant is there, such as his criminal record.
Are you going so far as to say that it's unlikely to be a matter of significant relevance?
It's unlikely to be the central issue.
That's not quite the question I asked. Are you saying it's unlikely to be a matter of significant relevance?
Well, on the face of it, it's not going to be one of the principal issues that drives the determination of such a question.
I think you're saying more than that, aren't you? You're saying that under the present regime, the policy is that foreign criminals should be deported.
Whether or not.
And whether or not they feel sorry for what they've done or reformed is neither here nor there. I mean, that seems to be the policy, isn't it?
That is the policy behind Section 94B and the deterrent effect. Whether or not you say you're going to reoffend.
It's not so much 94B is behind the whole, the previous act. Which
deportation.
I wonder whether this doesn't seek to take out of the proportionality equation a factor which will very frequently be in it, in the mind of the tribunal. Because the first thing that the appellant is going to have to persuade the tribunal about in many cases is that they have a deeper personal relationship and that their removal is going to be more harmful to the children, for example, than the Secretary of State has been disposed to accept. But I think you say, no, that will seldom arise.
Well, issues do regularly arise as to the strength of family ties, my lord.
But if that...
It doesn't follow that
can
only be resolved by...
Following Hesham Ali, they've got to be very compelling circumstances to justify not reporting.
Then there's going to be another question, isn't there, which is, given a general desirability to remove convicted criminals, which is the legislative policy, in order to establish that this is one of these exceptional cases, is it not likely that the appellant will be having to say, and what's more, not only are my personal circumstances exceptional, but also I am really able to demonstrate to you that I am a reformed character. That's why I put it to you that is likely, in reality, to be a matter of significant relevance. I think you're inclined not to agree.
I'm not inclined to agree with the last part of that observation, my lord, in the way in which it's put. But what I would say is this. Clearly, there may be exceptional cases where the tribunal is satisfied that oral evidence is going to be required in order to resolve certain issues of primary fact before it can come to a concluded view on a particular case. What I'm seeking to address is the proposition that inverts that and suggests that it's only in the most exceptional cases that you could ever contemplate that an out-of-country appeal could be fair for the purposes of the procedural requirements of Article 8. And I say that that proposition is just entirely unfounded. But I'm not seeking to exclude the prospect of cases in which the tribunal will deem it appropriate that there should be oral evidence, whether it's given in person or whether it's given by other means. And can I just, in that context, and this slips, I suppose, a little in the direction of the proportionality issue as well, but just looking at the question of procedural fairness in this context, take you, first of all, to the joint note that the parties submitted to the Court of Appeal, which is at MS 7261.
Which bundle is that in?
If my Lord just allows me, can you give me the bundle for?
This is one of the appendices.
We don't have MS numbers on our appendices, unfortunately, Advocate General.
Appendix 2, page 395, my Lords.
Thank you.
395.
Yes, my Lord. And your Lordships will see that the heading is Joint Note on Out-of-Country Appellate Procedure. And it begins by saying, this note is prepared on behalf of the parties to assist the court in relation to the tribunal's procedure and practice in out-of-country immigration appeals. All material referred to herein is contained in the agreed authorities bundle. So, in a sense, my Lord, it was an attempt to anticipate the point made by my Lord Carmarth that perhaps the most appropriate tribunal to consider how procedurally an out-of-country appeal should proceed was not the Court of Appeal, but the Immigration Tribunal or the Upper Tribunal itself. But it was, as it were, an attempt to address that point. And then there's a series of headings, provision of appeal forms. I'm not going to read it all out to your Lordships. Filing on appeal, and how it can be done in various forms. Case management at paragraph 11, that's at 7264. In most cases, the tribunal will normally give the following directions to the parties. So A1, witness statements of the evidence to be called at the hearing, such statements to stand as evidence in chief at the hearing.
So the in chief is significant, isn't it?
Indeed.
Because this contemplates cross-examination.
Yes, my Lord. But of course, if an appellant submits a written statement of evidence and he is not available for cross-examination, then on the face of it, that witness statement will stand.
Oh, well, it'll stand as his evidence. Doesn't mean that the Secretary of State is remotely bound to accept its accuracy.
Indeed. And there may be circumstances in which, if the Secretary of State is not prepared to accept its accuracy, it will say so to the tribunal, and the steps will then be taken to address that issue.
Like what?
Well, it will come on to the question of video evidence, Skype evidence, and also the question of supplementary statements being provided. There's also, finally, the point, my Lord, that if the Secretary of State is not able to ensure that there is a basis for challenge of such evidence, then the tribunal may decide that it must draw an inference in favour of the appellant, given the circumstances that arise. But the witness statement will stand as evidence in chief at the hearing. There'll be a bundle, a skeleton argument, a chronology of events, and so on. The tribunal can make directions in criminal deportation appeals requiring the respondent to produce details of the offence and sentencing remarks. It is made clear that in normal circumstances a witness statement should stand as evidence in chief, although there may be cases where it will be appropriate for witnesses or appellants to add to or supplement their witness statements, and reference is made to the relevant practice directions.
We're not going as far as to suggest, are you, that because the Secretary of State has exercised a power to remove the person from the jurisdiction and make him unavailable for cross-examination, the Secretary of State must, in fairness, in those circumstances, accept that his statement in chief should be accepted by the tribunal. You're not suggesting that for a moment.
It will be for the tribunal to decide what steps it must take in order to ensure a fair disposal of the appeal, having regard to the circumstances. And that takes us on to the next heading, which is video link conferencing, and reference the case of Kiarie and the provisions there, and the guidance on video link evidence. There's then at paragraph 17 a reference to the guidance note on video link hearings, which is of some antiquity, being 2013.
I mean, these are based on the assumption that the person applying to give video link evidence has a choice in the matter, not someone who's got to because he's not able to be in the country. And so, I mean, there's no guidance on this situation.
Well, that brings me on to a document that my learned friend Mr. Fordham took the court to earlier this morning. It's MS 6844. Because you may recollect that my learned friend Mr. Drabble very carefully said, as far as he was aware, there were no cases where video link evidence was employed. But the reason for that, I would respectfully suggest, is because technology has moved on. And what is employed in these circumstances is not the complexities of a video link, but Skype. And if your lordships refer for a moment to the letter again, MS 6844, and my learned friend Mr. Fordham...
Right,
Is this Bid's letter?
It is.
Very well.
I'm sorry, my lord, Bid's letter is actually 6841.
It's the reply to Bid.
It's Tribunal Judge Peart's response.
Right, thank you.
And my learned friend put this in context by taking you to the Bid letter, which is at 6841. And Tribunal Judge Peart replies to Mr. Maloof in July 2016, your letter to the President has been passed to me to respond. Directions are given on a case-by-case basis and are evolving as we understand what can be done with the available technology. For example, the Kiarie-type directions anticipated evidence by videos, such as we use in bail hearings, but we are now regularly hearing evidence via Skype with necessary additional equipment. We are happy to liaise with appellants' representatives at case management hearings to address how best to facilitate evidence from out-of-country witnesses. As regards this particular appeal in which you are involved, which has prompted this approach, do let me know if any particular problems arise which I can help with by way of further case management. Of course, an out-of-country appellant can always rely upon a statement and oral evidence from family here. I do accept what you say, that those without informed representatives with equipment might be disadvantaged. That is arguably also the case if an appellant is unrepresented because public funding is unavailable. In such circumstances, the tribunal will always ensure that no one is disadvantaged in terms of the outcome of the appeal because of lack of resources. And then the point that was alluded to by my learned friend, unfortunately the tribunal has no funds to provide equipment or technical ability, hence the onus in that regard we have to place upon appellants and their representatives. Various representatives have an interest and knowledge in these matters and are then referred to. All these practitioners have expertise in facilitating Skype evidence and use of equipment such as laptop, projector, Wi-Fi link and audio equipment. It is often the case that they set up equipment in advance of a hearing and even have a dummy run to ensure everything will work as they hope. I've copied my colleague designated Judge Campbell to this correspondence as we share case management responsibility for deport cases. We are always prepared to listen to the views of representatives and to meet with you to discuss your concerns if you feel that might be of some help. Now, I simply observe that what comes out of that letter is clear evidence that in the context of out-of-country appeals, the tribunal is in use of employing Skype as a means.
It's curious that this has only come up as a result of this, because I remember when I was involved, we were experimenting with the use of Skype, but I don't think it got very far. We got no other evidence about how it actually operates in practice and how good it is. And all we have is just this reference in one letter.
Well, Tribunal Judge Peart, as he says, shares case management responsibility at the tribunal for deportation appeals.
Yeah. I'm just surprised that no one on your side has actually got experience of the use of Skype, because it sounds as if it's actually happening quite often.
On the face of it, my lords. But the
This
point
may be very unfair, but what is the legal obligation of a government to provide an effective judicial system? Looking at it entirely generally.
I would acknowledge, my lord, that access to justice is a common law right.
Yes.
Yeah, but I mean, under the Constitutional Reform Act, the department has certain duties to provide an effective system.
But going to the very base level...
This is part of it, arguably. I mean, whether it gets down to this level, of course, is another matter.
Indeed.
You know, we can look at the Constitutional Reform Act and see what it says.
But
You are, in fact, representing the Secretary of State for the Home Department, are you not, Lord Keane? Although I know that you speak on justice matters in the House of Lords, so perhaps, whether you're wearing two hats or not, I'm not entirely sure.
on this occasion, my lady, I'm wearing only one hat.
No, but you can't. I mean, Secretaries of State have collective responsibility, I seem to remember somewhere.
Of course. I acknowledge that, my lord. But I'm not about to make any submissions on behalf of the Secretary of State for justice.
No, but it may become relevant to what extent it is your job to ensure that this thing works. I mean, whether qua Home Secretary or qua Secretary of State for Justice.
Again, coming back to the generality of cases, it is not apparent that in order to meet the requirements of procedural fairness under Article 8, it is a necessary requirement that an appellant should be available to give oral evidence in person to the tribunal in the course of an appeal. It's quite...
Yeah.
Well, I wonder how we can make that judgment.
After you, please.
That was what I was going to say.
In the light of our recent judgment in Hesham Ali, these appellants have a job on in these appeals. And really the question is whether the considerable hurdles that they face should lead us to indicate that there should be no more difficulties of a procedural character placed in their way. Or whether for some reason, because this is the public interest argument flowing through, the public interest argument which makes their appeal so difficult should in some way inform this particular decision, which is a view that you persuaded the Court of Appeal of, and you might be coming on to.
Well, in my respectful submission, one's got to look at the process as a whole. Parliament has determined that foreign national criminals should not remain in this country. It has therefore made provision for their deportation. It has further made provision that even in the event of them marking an appeal on human rights grounds, they may still be deported pending the outcome of that appeal. Ultimately, of course, if their appeal is successful, they may return to this country. In the meantime, insofar as there's a certification under 94B, it may be the subject of an application for review. But it is one continual process which springs from the desire that foreign national criminals should not remain in the country.
But if you accept that the review of the 94B certification involves close scrutiny, how can the reviewing court know in advance whether in a particular appeal, depending on how it develops, the oral evidence of the applicant will or will not be needed?
Because under the tribunal procedures, it is first of all a requirement that an appellant should give notice of his grounds of appeal, so that he should identify the issues that the tribunal is going to require to address.
But the application goes in once he's gone, doesn't it? He has to be out before he can appeal.
Indeed.
Yes. So his grounds of appeal won't be before the Secretary of State at the moment. She is certifying under Section 94B.
That is correct, but what will be before the Secretary of State is the very detailed questionnaire that is submitted to a party upon being given notice of an intention to certify under Section 94B. And this has particular relevance in the case of Mr. Byndloss. And can I just take you to Appendix 3 in the bundle at page 59. Sorry, if you just make sure I've got the correct reference. I won't be a questionnaire. It depends. I apologize, I've given you the wrong reference, my lords. It's Appendix 5, page 1328.
And the MS number?
8194, my lady.
Thank you.
1328 in
1328.
5. Thank you.
And MS 8194. And remember, we know what the individual has been convicted of. We know of his previous convictions. This questionnaire was returned by Mr. Byndloss's solicitors in October 2013. And they indicated that he might want to provide some further detail in the questionnaire. No decision was made on certification for a further year. During which time I understand that 2 letters or 3 letters may have been sent, and we can look at those in a moment. But just looking to the question of the Secretary of State's decision-making, at 1328, there are details relating to the appellant himself. At 1330, there are details of his solicitors or legal representatives, which he had. Then details as to how he entered the country. And then at 1332, he's asked about details of a spouse or civil partner. And then at 1334, we begin a lengthy section about children in the United Kingdom. And they're listed through to 1336. Thereafter, in section G, from 1337, there are a whole series of questions pertaining to each child. Largely concerned in the first instance as to their place of birth. But then at page 1340, begin a whole series of detailed questions. Prior to going to prison, being detained, did you live in the UK with your child? So for how long? Blank. Who has current care of the children? Please give full details. Blank. What is the current carer's relationship to the child? Blank. What is the current carer's relationship to you? Blank. Going on to page 1343, question 19. Please give details of any residence orders, contact orders, court orders, and any ongoing court cases relating to the child. Please give full details. Blank. In respect of each child. Going on to page 1346. If the child has a parent apart from you living in the United Kingdom, what is her his or her current immigration status, please give details. If you're a lone parent but know the whereabouts of the child's other parents, please provide relevant details. What other family does the child have? All blank.
But things moved on from there, Lord Keane. By the time we come to the supplemental decision letter, quite a lot of material had been provided, statements, so on.
No, my lord. With respect, I have to take issue with that. By the time of the supplementary decision letter in September 2015, very little additional material had been provided.
We were taken through it yesterday, weren't we?
Well, a lot of the material you were taken to yesterday was material that was produced after the supplementary decision letter in the days running up to the hearing in the Court of Appeal.
The critical ISW report comes after the supplementary decision.
Exactly. But a lot of the other material came after the second decision letter. What happened was that the solicitors or legal representatives of Mr. Byndloss indicated that they wanted to gather further material. It didn't appear, and there was an indication they wanted the hearing in the Court of Appeal to be discharged. There was concern on the part of the Secretary of State about such a discharge because there were a number of cases, as it were, queuing up behind these two cases. And the second decision letter of September 2015 was sent out. Thereafter, we received the social work report and a substantial body of additional material, which was never before the Secretary of State, even in the context of the supplementary decision letter. And it was that material that the Court of Appeal referred to when it observed that the Secretary of State would look at that material going forward in order to take into account whether or not the certification under Section 94B should or should not remain.
Has a decision been made on that?
That decision has not been made because it awaits the outcome of this appeal before that matter is addressed. But
We
clearly,
have yet another report I see in the Byndloss, the second intervener's papers, a report dated February 2017.
which came from the same, I believe it came from the same independent social worker as the first, but was actually provided to the second interveners. So there's that additional material as well. And we quite candidly acknowledge that all of that material will have to be looked at by the Secretary of State in order to consider whether the present certification should or should not stand. But that was not the material that was before the Secretary of State at the time of the second decision letter in September 2015.
I'd say, so even myself, I think I would find it quite helpful to know what the Secretary of State's attitude would have been to this new material, because apparently you told the Court of Appeal that you would be dealing with that. I mean, it'd be quite useful to know what the Secretary of State's position would have been in relation to this new material, or indeed would be now, whether we're dealing with a purely academic case or not.
Well, on the basis of the information that's now available, the Secretary of State, I anticipate, will be happy to accept that there exists a parental relationship between the relevant children referred to and Mr. Byndloss.
And does that mean you wouldn't certify?
That's a separate question, my lord.
I know it is. That's why I'm asking it.
I cannot say on behalf of the Secretary of State that she would not certify, my lord, because, as you know, there is a proportionality issue here. If I can use a phrase that was employed in an earlier case, the children are not a passport to Britain. It is a more...
We understand all that, but this is a real case of a real person who, as you now accept, has a parental relationship, which you didn't accept before. And I'd have thought it would be rather important for everyone to know, and particularly him, where he now stands.
Well, that is something that the Secretary of State will address in light of all the additional material that has come in, including the most recent social work report of about a week ago. But I can't take it further than that, my lord. But the point I make, and I make it in part to respond to the learned premise of Fordham, the Secretary of State did carry out very detailed inquiries for the purposes of Article 8 in order to determine the existence of parental relationships and the position vis-à-vis the various children that were referred to by Mr. Byndloss.
Yes, to vouch that, where do we find that in the papers?
The questionnaire.
Or just the questionnaire, yes.
Well, just the questionnaire. There's also correspondence from his legal representatives. And as I say, there were, I believe, 2 additional letters and a statement from one of his partners produced prior to the decision letter in September 2015.
Yes.
That was Amanda Craig. That was Amanda Craig.
I believe it was, my lord.
Yes, so you say the attack, standing the questionnaire, you say the attack on you for not inquiries under Section 55 is misplaced.
It is, in my respectful submission. And as I say, not only did we receive the questionnaire with the indication that from Mr. Byndloss's legal representatives that he might wish or he would wish to give further detail in the questionnaire, a decision was not taken for a further year, during which time no additional questionnaire was produced.
Where's the reference to where we may want to add to this?
If my lord just allows me one moment, it was in an earlier appendix, I think MS 7461.
Other number?
Appendix 3. So it's Appendix 3, page 485.
Thank you.
And I'm afraid that, like your lordships, I don't have an MS number on the appendices. And it's a letter dated 4th October
Yes, thank you so
2013
Yes.
From his legal representatives, saying we've been instructed by the above in relation to the deportation matter you're considering. We've been passed your letter and subsequent questionnaire, and you've asked our client to complete and return to you. Unfortunately, our client has had difficulties in obtaining legal representation, and we're only recently instructed. We've obtained some instructions from him, and given our client has missed the deadline you gave him to submit the form, we submit this partially completed along with the following evidence. And then there's a reference to further material.
So you say the inference was they were going to fully complete it later.
Oh, so we understood, my lord, on the basis of that intimation. But it is more to illustrate the point that the Secretary of State did undertake a proactive inquiry with the relevant parties in order to inform her as to the decision that she had to make pursuant to Section 94B with respect to certification. She didn't simply leave it to the appellant. I should add that in respect of Mr. Kiarie, there was also a questionnaire, but of course it was within perhaps shorter compass, given that there was no question of a personal relationship with a partner or spouse, and no issue with regard to children. But the relevant questionnaire can be found in Appendix 3, tab 45, page 447.
And have you got an MS number for that?
I'm afraid there are no MS numbers actually printed on this appendix, but I'm advised it's MS 7313, milady.
Thank you.
if one of the main issues in the forthcoming appeal is going to be the quality and value for the children of their relationship with the appellant, how damaging is it to that argument on the behalf of the appellant that he will have been gone for a year?
Well, my lords, first of all, I take issue with the reference to a year. I know my learned friend Mr. Gill referred to a year or more for the purposes of the appeal, but the information provided to me indicates that in the year 2015-2016, the average period for appeal was 14 weeks, and that the most up-to-date figures that take us to the beginning of 2017 indicate an average period of 20 weeks.
That's for out-of-country appeals?
For out-of-country appeals, my lord.
Say that again, how long?
It was 14 weeks, my lord. The most recent figures indicate that it is 20 weeks on average.
How damaging then, I must rephrase my question, how damaging is it to the appellant's case that he has a relationship with the children of great value for them as well as for him, that he will have been gone for virtually 6 months?
Well, my lord, that has to be seen in context. Obviously, that's a consideration that the Secretary of State will apply her mind to when she comes to consider certification in light of the current evidence and material. And it will have a material bearing upon the decision-making process. But to put that into context, my lord, the relevant deportation should take effect from the expiry of the relevant sentence of imprisonment. So it's not just a case of looking at a separation for a period of 14 or 20 weeks. It's a case of looking at a period of separation for 2 or 3 years, in the case of Mr. Byndloss, 2 years, followed by a period during which he has to go out of country for the purposes of an appeal.
Can I just ask about 20 weeks? 20 weeks from when? From date of deportation?
I suspect it's from date of notice of the appeal, my lord, but I'll check that. It will be from date of notice of the appeal because it's only from that date that the data would be available, my lord.
Because there's reference in the paper somewhere to the practice that a date isn't fixed for hearing the appeal until after the Secretary of State has got her papers in order. I don't know whether that's accurate or not. But anyway, you say on current instructions, the 20 weeks is from service of notice of appeal.
That's my understanding, my lord, but I will seek to confirm that during the luncheon adjournment. Just coming back to my Lord Wilson's point, it is therefore not a case of addressing the question of separation during the period taken for an out-of-country appeal. One is looking at the deferral of him perhaps re-establishing that relationship with the children following his period of imprisonment, whatever that length of imprisonment may have been.
Yes, but while he's been in prison, there has been some continuation of a relationship with visits, as in this particular case.
Indeed, sir. And other forms of contact, perhaps by letter or by telephone.
I mean, I was a judge of the family division for many years, dealing with care cases. And so often the magistrates at the beginning of a care case had made an interim care order that the children be removed from the parent. And when I came to decide it 12 months later, well, they'd been gone for 12 months. And the whole dynamic of the case was really completely altered by the fact that the parents hadn't had them living with them for that period. And so it is at the back of my mind that your decision may be actually cutting across a significant part of the appellant's proposed argument?
I mean, of course, it works all ways. I mean, a long period in prison, even if you have some contact, is not going to be very good for your parental relations. But, so one simply doesn't know. I mean, the interesting thing, looking at the latest ISW report, is in fact the period of this appeal and the fact that he's been able to have much more contact will actually strengthen the relationship. So how you bring that into the equation? I don't know.
Well, indeed. And of course, that is one of the things that the policy was intended to address, the idea that by marking an appeal and pending the appeal, you could build up a relationship or a further basis for saying that you had a link to the United Kingdom that would be interfered with for the purposes of Article 8. But I go back to my point to my Lord Wilson. It's not like the care order case, because normally the deportation certification should take effect upon removal from prison, with the result that it's a case of deferring the re-establishment of a relationship which has been interrupted by reason of imprisonment, not of breaking it. Lords, perhaps as we're on the issue of children, in the context of the Byndloss appeal, I can just notice also the points that we make in our case at paragraphs 121 to 126. I don't want to take up time unnecessarily with the point. Your Lordships will have read it. And at MS 6785, there's simply the heading, the approach to Article 8 in deportation cases involving children. And at 122, there's a reference to the ZH Tanzania case, and in particular the judgment of Lady Hale, where she explained the important distinction between decisions which directly affect the child's upbringing, such as the parent or other person with whom she is to live, and decisions which may affect her more indirectly, such as decisions about where one or both of her parents are to live. The question of who has primary care of the child. And at 124, I won't go to the cases themselves unless your Lordships wish me to do so, because the quotations are there. But it's the case of H, which is at MS 2069, and a reference to an observation from, again, Lady Hale at MS 2116. In the first instance, the information is likely to come from the parties, as there will be no pre-sentence report. The court will need to know whether there are dependent children, whether the parent's removal will be harmful to their interests, and what can be taken to steps can be taken to mitigate this. This is in the context of an extradition case, as my lady will be aware. In the more usual case, where the person whose extradition is sought is not the sole or primary carer of the children, the court will have to consider whether there are any special features requiring further investigation of the children's interests. But in most cases, you should be able to proceed with what it has. The cases likely to require further investigation are those where the extradition of both parents or of the sole or primary carer is sought. And there is no general requirement, my lords, that the children themselves should be asked to state their views, either in person or to a social worker about the children. And indeed, there would be potential problems if that was to be done, given that the children themselves might then fear that they somehow had played a part in the deportation of a parent. Reference also is made to the case of Khan in the United Kingdom, where the court took the view that in the first instance, the onus was on the applicant to explain why his deportation would be seriously harmful to the interests of the children. And again, it simply underlines that it's a matter of context. There will be some cases where the parental relationship is so clear, so well established, and so important that it would not be appropriate for the recertification pursuant to Section 94B, even at the end of a period of imprisonment. But that is a matter for the Secretary of State to address on a case-by-case basis in the context of the information that is provided to her in response to her primary inquiry by way of the questionnaire. Now, can I move on slightly, my lords, to a point that is related to this, which is the question of what information was available to the Secretary of State, and over and above that, the making of the supplementary decision of 3rd September 2015. And in that context, reference was made to the case of Karupan, which is in volume 10 at tab 117. And perhaps just to put this in context, I should note what the decision letter of 3rd September 2015 actually did. In our case, it did two things.
So could I have a MS number, please?
Yes, my lady, it's 3542 that it begins. First of all, the decision letter of 3rd September 2015 did take account of further material or evidence served by Mr. Byndloss's representatives in the course of the JR proceedings, right up to the week before the hearing in the Court of Appeal. And secondly, it corrected a potential defect in the decision-making process concerning the Section 94B certification, inasmuch as it addressed the correct question of whether a return to Jamaica would be unlawful under Section 6 of the Human Rights Act, rather than just whether there was a risk of serious irreversible harm, as provided for by subsection 3 of Section 94B. So, to use the language of Lord Justice Underhill in the case of Karupan, it was a mixture of a fresh decision case and a new material case. And I refer in that context to his observations at paragraphs 31 and 32 of the judgment. And at 31, he deals with what might be termed the fresh decision case. And at paragraph 32, he deals with the further material case. Now, Lord Justice Underhill endorsed the long-standing position set out in Turgot, namely that where the Secretary of State has issued a fresh decision, taken in light of new material served during the course of the proceedings, it will in general be convenient to substitute the new decision for the old. And it will simply be pointless to consider the validity of the old decision and indeed, the inference is that a claimant submits new material with the intention that the Secretary of State should take it into account in the decision-making process. Now, of course, the fresh decision does not affect the lawfulness of the original decision. If that original decision was unlawful, then it remains unlawful. But it does affect the remedy, because if the court concludes that the fresh decision is lawful, there will be no remedy. And that is the view that the Court of Appeal took in this case as well. that it should address the decision.
Yes, your position is the supplementary decision letter is the only operative decision.
Precisely.
Yes.
And what of the point that it didn't really give Mr. Gill's clients time to respond in detail, or indeed time to produce the ISW report?
Well, with respect, my lord, they've been given, in effect, 2 years. 2013, they received the questionnaire and returned it in October 2013. A year passed, during which very limited material was added to that which had been submitted. And the first decision was made a year later in October 2014. Thereafter, as matters proceeded by way of the application for judicial review and the applications for permission to proceed, it was indicated that they would want to submit further material. Some further material was submitted, but as we reached essentially the door of the Court of Appeal, it became necessary to make the supplementary decision, and it was made on 3rd September. Thereafter, I accept, an avalanche of material came in from the representatives of Mr. Byndloss. But I don't know how long we might have been waiting for that avalanche, but for the second decision letter. And the Secretary of State's position is that clearly, once this appeal is disposed of, she will address that additional material, and indeed the further material which has been lodged on behalf of the second interveners, which includes the supplementary social work report, in order to review the certification that has been made. But it respectfully appears to me that the effective decision that has to be addressed is the effective decision that the Court of Appeal addressed, namely the decision of 3rd September 2015. I've concentrated on the position of Mr. Kiarie so far, but looking at the proportionality of the decision in the case of Mr. Kiarie...
Yeah, I think you've been concentrating on Mr. Byndloss.
I apologise. Did I miss...
You said Kiarie.
I apologise. It occurred to me that I should also address the proportionality of the decision made in respect to Mr. Kiarie, as we have spent such time with regard to Mr. Byndloss. And as regards the proportionality analysis in his case, I would just make a few short points. As I've indicated, the removal should have occurred at the end of his sentence and would therefore have been a deferral of his return into society in the United Kingdom. The removal on the face of it will only be temporary, pending the outcome of his appeal. And the information I have is that it should be an average of about 20 weeks from the date of notice of his appeal. On the information that was available to the Secretary of State, he's relatively young and in good health. He has no children and no partner. He has no job and he's not in education. So from that point of view, his temporary removal will not significantly disrupt his life in the United Kingdom. He has family in Kenya. He's visited that country on many occasions. The principal language of the country is English. And indeed, in a curious way, those representing Mr. Kiarie appeared to acknowledge that he did have the capacity successfully to integrate in Kenya, even during this short period. Indeed, it was a point they made before the Court of Appeal, but not before this court. And they made it in this way. they advanced the argument that he would be disadvantaged by his temporary removal to Kenya because potentially it would demonstrate his ability to integrate there. And that would take away from the merits of his appeal as it was ultimately heard.
Proof in the pudding, proof of the pudding, yes.
I just noticed that the Court of Appeal dealt with that line of argument at paragraph 62 of their judgment. It's at MS 6887.
Yes, your position is that knowing the reality is better than knowing a prediction.
Well, indeed. What they said, in response to the complaint that requiring Mr. Kiarie to return to Kenya pending determination of his appeal would unfairly undermine his argument that there are serious obstacles to his integration in Kenya, Lord Keane makes the obvious point that it cannot be unfair for the tribunal to take account of evidence that shows that the Secretary of State is correct in her view that given his age, state of health and education, he is likely to be able to establish social and cultural ties in Kenya and to gain employment there. There is no merit in the argument because it might be more advantageous to the appellant if the tribunal had to speculate about his prospects of integration. It is somehow unfair for the tribunal to proceed on a better informed basis. As I say, I notice that this line of argument is no longer deployed in this court, but it underlines his own belief in his ability potentially to integrate, even for a short period, back in Kenya. So in those circumstances, I would observe that there's nothing here when addressing the proportionality argument that is sufficient to outweigh the strong public interest as declared by Parliament through Section 94B. And I would add only one further point to this. In the case of Mr. Kiarie, he has already been given a second chance so far as his criminal conduct is concerned. On the first occasion that he came before the court was persuaded that it should not at that stage impose a custodial sentence. Consequently, Mr. Kiarie went out and continued with or re-established his habit of supplying Class A drugs and came back to court as a consequence of that. So even if we were to address it in the context of individuals being given chances, Mr. Kiarie most clearly had his chances before he served, or ultimately served, his sentence of imprisonment. So again, I say that there is nothing in the argument that has been made on proportionality on behalf of Mr. Kiarie to justify any challenge to the decision of the Secretary of State to certify, and the Court of Appeal was quite right to arrive at that same conclusion. It did apply anxious scrutiny to the decision-making process, the facts upon which the Secretary of State relied, and it applied the correct test in doing so. And it was entitled to the view that an out-of-country appeal would not only be Article 8 compliant in the context of procedural fairness, but proportionate in each case. That being so, I invite the court to refuse the present appeals. I was going to raise the question of whether there were points made first thing this morning by my learned friend Mr. Fordham that the court would wish me to address. And I wonder if I might be permitted, given the time, to seek an adjournment rather earlier than usual so that I can address those points and return to them after the luncheon adjournment. I don't anticipate that I will take up anything like the further hour that has been allotted to me.
I had somehow got that impression, Lord Keane. I'm sure that my lords will be happy to adjourn, and if you won't need any more time as a result of being deprived of.
May I just mention one matter before you do? You said what the material was in B's case at the time of the second decision letter. I thought there was rather more to it than that. And in fact, there was in I think October 14, his solicitor served the pre-action protocol letter with a raft of stuff attached to it. One of the documents was the prison visit documents. I've been working my way through that, and it appears to me that 3 of his children were very regular visitors throughout the entirety of his time in custody every month. Other children were less frequent visitors. Now, none of that got referred to in the supplemental decision letter, but it does make, if one's applying strict scrutiny, does make the assertion that there was absolutely no relationship with his children, perhaps surprising at a time when they had been visiting him in prison on such a regular basis.
Well,
I throw that
yeah, no,
at you for your reflection. Your time is spared.
No, could I knock it back just for a moment? But I will double check this. My understanding is that this material was supplied on about 18 September 2015 after the second decision letter, but I will check that.
I will check that. Not on the face of the document. It's in Appendix 5, 1188, and I'll get the MS number for it in a moment. 8054 is the 27th of October, and I had understood, but I may be quite wrong, that the tranche of documents which followed it went with the letter, but I may have got that completely wrong.
I don't believe that's the case, my lord, but I will double check that during the adjournment.
I think that was the way it was presented to us, but...
Your Lordship has it absolutely right. That is exactly right.
Right.
Well, I will check that, my lord, because that's not my understanding of the position.
And I think you were prevented from saying when we would come back.
Exactly so, yes. I was going to say that as Lord Keene does not require the time that he is now losing to be made up, we will return at 2:00.